Hi, everybody. This is Andy doing another case review. First of all, do apologize for the poor lighting. I'm in the middle of moving, so this is currently where I'm sitting right now at home. Anyways, I'm not a lawyer, but I'm doing this for an immigration tribunal class. This case number is this is in the federal court just about a month ago, just over a month ago. Case number 2020, federal court, case number 785. Regarding a application for a spouse under the family class. A couple points of law that I found interesting, and I'll try to keep it short because the case itself is fairly quick to read. So I'll just go to the slide deck. So basically, this the pertinent regulation is in section number 4, obviously, which covers bad faith relationships and whether or not a new relationship was entered in just for the purpose of obtaining some kind of status in Canada. I think I've read these sections previously, so I'm just going to leave this up and for a second, but I'll get to the points of law that were brought up in this particular case. And actually, the first one is regarding a language interpretation. So what I found interesting is that Mr. Boparai, the applicant, he brought forward a case, and the minister's representative brought forward their own case reference. But in the end, the trial judge brought forward, I guess a more current case regarding language in the legal requirement for language in interpretation. And they cite, I'm going to mispronounce this, Mo, Lohi versus Canada, Singh versus Canada, and Mohammedian versus Canada. And yeah, I mentioned that the same the same set of cases was mentioned in a very similar case that I did a couple of weeks back. But anyways, in essence, language interpretation doesn't have to be perfect, but it's just to make sure that there is a clear linguistic understanding. And not only that, but the applicant had the right to raise their concerns. If there was a concern, the applicant had to have raised it right away versus waiting until they got a decision that they didn't like. So the applicant cited this case, and like I said, the minister's representative cited a whole other case, but then more currently, this is the case that's been currently used with regards to what is the necessary level of language interpretation. So I found that kind of interesting that even the minister's representative wasn't actually following the most current one. Let's see, what else do we have? The other point would be, and this is mentioned in paragraph 17 of of the of the uh, of the hearing, in that the applicant brought forward their own the applicant brought forward their own expert witness, but the expert witness brought forward his own opinion versus just sticking to the facts, and that was in a violation of Rule 10, subsection 2, paragraph D, in that his expert opinions was not limited to facts, which it had to be. So his testimony was subsequently withdrawn from this case. So to summarize the issue with translation, in paragraph 29, the judge said the following: the right is to adequate translation, but not perfect translation. And the fundamental value is the linguistic understanding. The waiver of these rights results if an objection is not raised at first opportunity. there's no evidence that Mr. Boparai's counsel before the IAD, fluent in Punjabi and English, raised any issue relating to the quality of the translation. And so Mr. Boparai thus waived his rights. And then lastly, because this case is so recent, they cite Babylon versus Canada, which is a new standard of review for reasonableness. And again, and this is similar to reading that we had a couple weeks ago, in that it's not, as long as um, the tribunal meets the standard of review, judicial review, judicial review, it's not the task of the trial judge to reweigh the evidence. And I think this is going to come up. This came up last week, and it's obviously in this week's case too. In that, and they use the same wording. The applicable standard of review is presumed to be reasonableness, and nothing rebuts this presumption in this case. Reasonableness is a single standard that counts for this context. The decision must be justified, intelligible, and transparent to the individuals. So, and again, and I highlighted this, its task is not to reweigh the evidence. So to summarize, I mean, this like I said, this was pretty short. The appeal was a couple of different things. One, asking for an appeal regarding the translation, and I just basically outlined, same reasoning. Translation doesn't have to be perfect; just has to be clear enough. And if there was a issue, the applicant must bring it up right away. And secondly, for judicial review, it's not their job to reweigh the evidence, but just as long as the decision-making process meets the standard of reasonableness, then there is nothing to appeal for. Anyways, thank you very much. Sorry, this one's a little choppy, but hopefully I'm getting better over time. Thanks.